Welcome to this explainer. Today, we're unpacking a monumental piece of legal history, JT Publishing versus the Minister of Safety and Security. It's a fascinating 1996 Constitutional Court of South Africa case packed with censorship, intense procedural roadblocks, and a massive plot twist at the very end. If you've ever wondered how the highest courts decide what they will and won't hear, we're going to map it all out for you right now.
Imagine you spend a ton of time, money, and energy fighting a law that is actively harming your business. You take the fight all the way up to the highest court in the land, only for the ground to completely shift beneath your feet at the final moment. That is exactly what happened to the publishers in this case, and the way the court handled it set a huge precedent for how judicial power is actually exercised.
Section 1, the censorship battle, begins. Let's rewind a bit to set the scene and see how this all kicked off. We're in 1996. South Africa is navigating its new democratic interim constitution, and the boundaries of free expression are really being tested. JT Publishing, the company behind Hustler magazine, and one of their franchisees get hit incredibly hard by the authorities. Their magazines are banned outright under the old 1974 Publications Act, and this wasn't just some abstract debate. Police were literally raiding their premises and confiscating their merchandise. The state was aggressively using apartheid-era censorship laws to shut them down. Here's the wild part. The government actually knew the law was constitutionally suspect. The Minister of Home Affairs admitted it was flawed, and his department was actively writing a new bill to replace it. So the publishers reasonably asked, hey, could you maybe stop the police raids while you fix the law? And the government flat out refused. They insisted on enforcing the old, broken law anyway, leaving the publishers with absolutely no choice but to sue.
Section 2, a procedural roadblock. You'd think getting a bad law struck down would be straightforward, right? Well, not quite. You can't just walk through the front door of the Constitutional Court. You usually have to go through a lower court first. So the publishers asked the Supreme Court to refer the censorship laws up the chain for a constitutional check, but they hit a massive wall. The applicants only asked for the constitutional check. They didn't ask the lower court for damages or any other relief. The constitutional question was the sole issue on the table, and for the lower court judge, that was a huge problem. Judge Daniels totally blocked them. He basically argued that you need an existing wider legal dispute, a lis in legal jargon, not just a standalone constitutional question. Because they didn't have other non-constitutional issues attached to their case, Judge Daniels called their request incompetent and threw the whole thing out, leaving them out in the cold. Section 3, the route to the court. So how do you actually get to the Constitutional Court when a judge shuts the door in your face? Normally, you have two paths. Path 1 is an ordinary referral from a lower court, which they just tried and failed. Path 2 is direct access, going straight to the top. But direct access is incredibly rare, reserved only for extreme urgent emergencies where the public is at risk. Our publishers didn't easily qualify for that, so they had to take a massive detour. They actually appealed Judge Daniels' refusal, turning this into a massive fight over legal procedure just to get a hearing. Section 4. The Constitutional Court rules. The publishers finally make it to the highest court in the land. Judge Didcot and his colleagues step in to review Judge Daniels' roadblock, and they completely tear it down. The Constitutional Court looked directly at the text of the Constitution and essentially said, there is no way the founders meant to lock people out of the justice system just because their only complaint is a constitutional violation. Using some crystal-clear logic, Judge Didcot dismantled the lower court's ruling. First, he pointed out that Section 102, subsection 1, applies to any matter. It absolutely does not say you need a bunch of non-constitutional issues tacked on. Plus, subsection 17 explicitly outlines the right to appeal when the only issue is constitutional. The Constitution literally planned for this exact scenario. So, huge victory for the publishers. The Constitutional Court officially overturned Judge Daniels. They ruled the referral was totally valid, it served the interests of justice, and it should have been granted in the first place. The lower court's refusal was officially swapped out for a proper referral. The censorship laws were finally on trial at the highest level. Section 5. The twist of mootness. The table is set. The arguments about censorship and free speech are ready to be judged. And then, we get our massive plot twist. To understand what happens next, we have to talk about a declaratory order. That's what the publishers wanted, an official statement from the court declaring the censorship laws invalid. But courts have a strict, long-standing policy. They do not like wasting time on abstract or hypothetical questions. They only deal with real, live controversies that actually change things on the ground. And while these lawyers were locked in this intense courtroom battle, Parliament was quietly working in the background. Remember that new replacement bill the government mentioned earlier? Well, they passed it. The New Films and Publications Act of 1996 completely wiped the old apartheid-era censorship laws off the books. Poof, gone. The very laws the police used to raid the publishers simply didn't exist anymore. This led to a real mic drop moment from Judge Didcot. He wrote that the whole situation had become wholly academic and of purely historical interest. Because the old laws were dead, striking them down wouldn't actually give the applicants or anyone else the slightest practical advantage. The threat was already gone.
So, despite spending all that time and money fighting tooth and nail just to get through the door, the Constitutional Court completely refused to rule on the censorship laws. The issue was legally moot. Since they couldn't fix a past wrong under a dead law, and there was zero future threat, making a ruling would be nothing but a hollow exercise.
Let's look at the final scorecard. The publishers won the procedural fight. They proved the lower court wrong. Because of that, the Constitutional Court forced the government to pay the publishers' legal costs for the appeal. A nice financial win, for sure. But the main events, the actual constitutional ruling on those censorship laws, the court stayed completely silent.
It leaves us with a really provocative question. Should our highest courts answer questions just to set the record straight, or should they only step in when there's an actual practical fight to be won? This case is a true masterclass in the pragmatic reality of justice. You can fight for years, just ask a question, only to find out it doesn't even matter anymore. Thanks for joining me for this explainer, and keep questioning how the system really works.